Securities Appellate Tribunal is missing a presiding judicial officer for over a year. At the Income Tax Appellate Tribunal, the last 3 presidents appointed by the government were temporary postings. The National Green Tribunal is severely lacking in infrastructure. Its 2 courts are in 2 different locations. The Debt Recovery Tribunals face a backlog of over 30,000 cases amounting to over 1 lakh crore rupees. And the Competition Appellate Tribunal doubles up as the Appellate Tribunal for the Airports Economic Regulatory Authority. Wait, it gets worse. There are stories of tribunal hearings being held in a canteen for the lack of space, presiding officers travelling by taxi, and random pay scales for members. This dismal state of affairs at India's myriad and ever-growing tribunals is counterproductive to the cause of their existence and seriously jeopardizes the validity of their orders. Hello and welcome to The Farm. Joining me this week are retired Supreme Court Judge Justice Ganguly and Senior Counsels Arvind Datar and Mukul Rohatgi. Gentlemen, to all 3 of you, a very warm welcome. Mr. Datar, I'd like to start with you by bringing up the issue of the invalidity of SAT orders, given that it has been missing a presiding judicial officer for almost a year now. This has been raised by Sanjay Jain in a writ petition in the Bombay High Court, and most lawyers I speak to believe that without a presiding judicial officer, SAT orders could in fact be held null and void. What is your view?
Well, there is a serious doubt about the legality of these orders. The last chairman retired last November, and there is a provision that suppose there is a defect in the composition of the tribunal, it won't affect the order. But that's only for a temporary period. There's some small problem. But I don't think the law permits you to have a headless organization for 11 months and 12 months and so on. So it is a serious problem.
Mr. Rohatgi, what is your...
In my view, the orders would be seriously open to challenge.
Mukul Rohatgi, Justice Sodhi, who was the presiding officer at SAT, retired last year in November. For the last 1 year, there has been no presiding officer. P.K. Malhotra, who is a member of the SAT, has been appointed as officiating presiding officer. But the point made in this petition, and I might mention in a side note here that the petition is filed by somebody who has a vested interest, because he's been fined 8 lakh rupees in an FUTP proceeding by SEBI, and he's appealing that at SAT. But nonetheless, the point made in the petition is that a temporary vacancy may allow for an officiating presiding officer, but a 1-year vacancy cannot be deemed to be a temporary vacancy. In your opinion, would the orders of the past 1 year be held null and void?
See, on this specific issue, I would tend to agree with Mr. Datar. But I have a more fundamental question to raise.
Sure.
And that is this, that the idea of having tribunals was to have experts in the field manning these tribunals who understand the complexity of the special law with which they deal in. Idea was to unclog the high courts, because the high courts have long pendency, and then provide maybe one appeal to the Supreme Court. But if you do a legal audit, see where we have reached. We don't have infrastructure, we don't have experts, we have only by and large retired bureaucrats or retired judges. And I say with respect, since Justice Ganguly is also with us, that none of them are experts in those special lines, and you then have a tribunal which consists of, placement of retired personnel, and finally 50% of these cases then land up back in the High Court, increasing the pendency which was supposed to have been removed. And from the High Court they go to the Supreme Court, and the remaining 50% land up in the Supreme Court in any case. So you are creating, you don't have infrastructure, you don't have money to pay people, you don't have experts, you don't have cars, you don't have staff, you don't have a place. The idea of unclogging the High Courts is no longer visible in the scenario. So the better thing would be to invest all these jurisdictions back in the High Court, create several divisions in the High Court, like a commercial division, tax division, securities division, advanced ruling division, and so many other divisions, and man them with expert lawyers who can be made judges, who have done this branch of law of the last 10 or 20 years. And maybe it could be better off, because the High Court is in one place, you could add some more infrastructure instead of having 100 tribunals moving around in Delhi. I mean, we have not less than 50 tribunals. Let me give you an example. We have a tribunal of what is called an advance ruling tribunal. It's a very important tribunal. The idea is that people from abroad who invest in this country must know the taxation structure if they come in. So you get an advance ruling before a dispute arises. I have come across any significant advance ruling in the last couple of years. So what is the great point of having them when finally everything ultimately gets clogged back in the High Court or back in the Supreme Court? So I suggest, if you want to have tribunals, have only experts manning them with proper infrastructure. Otherwise, do away with these tribunals.
All right, that's a fair point, and I think in a sense you've gotten to the core of this debate right away. Let me take this to Justice Ganguly. Sir, a twofold question for you. First, both the senior counsel on this discussion believe that without a presiding officer, the orders of the Securities Appellate Tribunal could in fact be held as null and void. What is your view? If that is in fact the case, then the last 1 year of orders would be dismissed, would be held null and void. What does that mean for the litigation that's taken place over the course of the last 1 year?
Well, I tell you one thing, justice is basically rooted in confidence, Therefore, people to have confidence in the system must have a properly structured tribunal. About the validity of the order, I refrain from making any sort of comments, since this is a pending matter before the Honorable Supreme Court. I mean, it's not a done thing for a judge to comment on that. But anyway, I'll go to the core of the issue, which has been slightly touched by Mr. Rohatgi. The question is, that Mr. Rohatgi has said, and rightly so, that these tribunals have been created to unclog the High Court. First of all, why High Court is getting congested in our country. You see, it's a well-known fact that the litigant and the judge ratio in this country is the poorest, even poorest among developing countries. This is number one. Even then, the vacancies which are there in the high courts are not filled up for various reasons. Entirety of this same is not lies in the hands of the government, but the government is also to be blamed for it. The third question is, you have in the High Court, if I may say so with great respect, not sufficiently competent judges. The selection process in the High Courts and also in the Supreme Court is open to serious criticism. I am not criticizing the collegium system. I am criticizing that in collegium system, always fair selection on merit does not take place. Therefore, you have incompetent judges, you have huge vacancies in the High Courts and also in the Supreme Court. Therefore, the cases are piling up because you are making so many laws without an impact assessment of judicial.
Justice Ganguly, forgive me for interrupting you, but let me put this question to you differently. I understand there are several vacancies in both the High Court as well as I think in the Supreme Court. The question I'd like to ask you is this: why are judges so averse to manning tribunal positions? Because I'm not sure whether it is that the Finance Ministry has been dragging its feet, at least when it comes to the Securities Appellate Tribunal, or is it that they're unable to find a judge who is agreeable to in fact take on the position of presiding officer at the SAT?
I'll answer you. The judges are. These days it is fashionable to bash the judges. Now the judges have been attacked by very eminent people, I don't want to name them, for accepting the tribunal position after the retirement. I mean, some learned, previously they were members of the bar holding very important position. They are saying there should be 2 years cooling off period. Now I can tell you about this National Green Tribunal. Initially there was a judge, Supreme Court judge, who took it up. I think Justice Panta, because of very poor infrastructure, he did not accept it. Then it was offered to Justice Ravindran. I think the whole thing was so dilly-dallied that Justice Ravindran rightly failed a bit. I don't know, I haven't ever talked with him, but he also declined. Now there is no third judge. On that also there has been some controversy which has recently cropped up. So judges are not very keen to take it up.
But that may
Many
apply.
judges I
That
know.
may apply, sir, to the National Green Tribunal. The Securities Appellate Tribunal
No,
at least
in
does
many
have
cases-
some
in many
infrastructure.
cases-
Is located in Mumbai, which is the commercial capital. I understand has pay scales comparable to such similar government positions. So I'm just curious to know why is it? Is there any other reason that judges choose not to man tribunal
I
positions?
do not know the reason, but I can tell you one thing. There are many judges who are retired judges in Mumbai, who are placed in Mumbai. But I don't think the vacancy has been filled up. Because the judges are not very keen to accept this position.
Why are they not
Because
keen?
they are
That's the
not-
question I'm asking you, Justice Ganguly.
Why should they be keen? Because look at, they have held very high position. They have held very high position. They have done their duties to the best of their abilities. They have held their heads high.
All right,
Very few self-respecting judges will be willing to accept this position. I tell you.
All right.
And look at the.
I think you may have hit upon the core of this
just
issue.
a minute. Look at what has been said in that famous case, El Chandra Kumar. In El Chandra Kumar's case, in 1997, as early as 1997, it has been said by a constitution bench of this court that this tribunal, there must be a supervisory body. There must be an independent agency. If it is not possible to have an independent agency, the nodal ministry, the law ministry should look after the administrative setup. Nothing has been done.
You see, I just spoke to some very eminent retired judges and asked them that why is there a reluctance on the part of High Court judges to accept posts of chairmanship of tribunals. And one answer I got from a variety of judges, some very good judges, is that they don't have the same service conditions as they had as High Court judges. They don't have infrastructure. They are at the mercy of the bureaucracy for simple things like travel, car and so on and so forth. So the feedback I got was that if you make the service conditions and the same as what they enjoyed as a High Court judge, then they wouldn't really mind becoming members of the tribunal for a further period of 3 years.
You've argued at the Securities Appellate Tribunal since we started
Yes.
with that, illustration.
Yes.
You know that it has maybe better infrastructure than most other tribunals in the country. Why
Yes.
do you think that the
Yes.
SAT has failed to be able to find somebody? Is this that the government is dragging its feet? It doesn't really want to appoint judges in these positions? Because that's another accusation that the tribunal system faces, that the government has converted this into sinecures for retired bureaucrats, and that tribunals
Yes.
are full of technical members who may not even have experience in that specific industry or field.
May I answer this?
Go ahead, Justice
May I
Ganguly.
try to answer this from a judge's point of view? I tell you that the government, or whatever color it may be, never wants a strong judiciary. Let us start with that. Let us look at our constitutional vision. Constitution talks of equal justice. The Constitution does not talk of a justice, one kind of a justice in High Court, and a kind of secondary justice or a second-rate justice in the tribunals. The tribunals are replacing the High Court, so they must be of equal stature, of equal eminence, of equal independence. Now, what is happening? You see, they're all the sponsoring ministry is sending an administrative member. Those persons, this I am not saying on my own, this is recorded in Ravindran's judgment. They are sending those people as administrative members who are still working, and they retain the lien in the sponsoring ministry. Now think of a situation.
Yes.
Suppose you make me the judicial member. As my partner who is on the bench, I will get a person who is coming from the sponsoring ministry, and that sponsoring ministry is the litigant before me, and that gentleman who is my partner on the bench is having his lien in that ministry. Where do you expect justice?